welcome back to the Washington Outsider Report on the Coalition Radio. For those newly joining the program, my name is Irina Zuckerman, and I am the editor-in-chief of the Washington Outsider. With us today, we have a special guest, Tor Ekeland. He's a managing partner at a law firm, and he's actually a fellow Fordham Law alum, as a matter of full disclosure. He'll tell us a little bit more about his professional background, but the big issue we are facing today is the use of innovative technology, and especially everything related to cryptocurrency and to identity tracing in the field of criminal justice, and how it impacts the pursuit of justice for criminal defendants. Tor is now appealing a major case involving an individual named Roman Sterlingov, and we will discuss what happened, how these issues came to play in this case, and the controversies around them. Tor, thank you so much for joining the program. We'll start by telling us a little about yourself and how you ended up in this unusual area.
Yeah, so I've been representing federal criminal defendants accused of computer crimes for over a decade now. And I first got into this after I left my corporate law job in 2010. I picked up a case representing a hacker who had been accused of essentially copying 114,000 email addresses from one of AT&T's publicly facing servers. To make a long story short, I didn't know it at the time. I was just like wanted to do a trial, right? It was like my first trial. It turned out to be a really, really big computer case. Our client was convicted at trial, which was no surprise. There's a 99% conviction rate in federal criminal trials, and this guy was a very, very controversial person, a very infamous internet troll, but we ended up winning it on appeal. It was a huge case, and that just sort of launched my career in representing a lot of hackers, sort of computer dissidents and whatnot, both in the United States and in Europe, mainly London. And so that for like the first decade, I did a lot of stuff involving the Computer Fraud and Abuse Act, which is the United States' primary statute for charging people with computer crimes. And then, well, actually, I started using Bitcoin because in 2012, we were trying to raise money for this first case, and somebody said, "Do you take Bitcoin?" And I said, "What's Bitcoin?" And they said, "It's money." And I said, "Of course I take it, right?" So it was like trading at like $42 a Bitcoin back then. And I never thought it was like a big deal. And this hysteria around it that's arisen, I just find a little strange. Like there's all these people who are like, it's not money, right? Okay, I mean, I can buy goods and services with it, and I've been using it like for money for like, I don't know, the last decade. The thing I like about Bitcoin is that it's just really fast and efficient. It's easy to move across borders because the banks still use software systems from the 70s. But fast forward to about two and a half years ago, we got this case it sat on our desk for a little bit. Because when I first read it, I was like, oh, this guy probably did something like everybody else thinks, right? And then I went down and I talked to him, and along with Mike Hazard, my senior associate, who's worked very closely with me on this case. And I was like, holy shit, you're innocent, dude. And that kind of changed everything. And what this case was, United States v. Roman Sterlingov. Roman Sterlingov was a dual Swedish-Russian citizen. He moved to Sweden from Russia when he was 14 and never kind of went back. And he got into Bitcoin early in like 2010. And he started using what's known as a Bitcoin mixer, which hides it breaks up any kind of tracing. A Bitcoin mixer will hide sort of like the source and the flow of your funds. And that's important for privacy reasons. I've even like found out because I've had people tracing my Bitcoin address that I use for legal donations for this case. And somebody was like, you got $1.4 million worth of donations and you're a greedy pig and you're spending all this money. I'm like, And I realized, no, that's the same Coinbase address I've been using, since I got a Coinbase address, like, I don't know, back in 2013, 2014, something like that. And what they did is they were looking at all the Bitcoin that had ever come in through to that wallet address, right? And what that illustrates is that if somebody knows a wallet address, like a Bitcoin address that belongs to you, they can see how much Bitcoin you have, right? And if they know that, what happens, these things that happen, then they're called wrench attacks. Like somebody will actually they'll physically come and mug you or steal your private keys to your Bitcoin address. So that's why things like mixers exist, right? Because a mixer will hide
Mhm.
where your the source of your funds and how much Bitcoin you have. So he starts using a mixer around called Bitcoin Fog around 2011, 2012. And what the government accused him of, and what he was just convicted of, in a very scary way, because there's no eyewitnesses or any kind of corroborating evidence that direct evidence ever shows him operating Bitcoin Fog. The government convicted him of operating Bitcoin Fog for 10 years and laundering roughly $334 million worth of darknet funds, that they were saying were coming from Silk Road and all these markets and being mixed in Bitcoin Fog, right? Um, and they convicted him in Washington, D.C., a place he'd never set foot in, and that the government admits the only thing that ever happened in Washington, D.C. was IRS agents mixed some Bitcoin through Bitcoin Fog. Um, and the entire case, and this is a very disappointing verdict for us because the entire case is built on circumstantial evidence and these traces where they say in 2011, money going from Bitcoin going from his KYC Mt. Gox account. Now, KYC just means know your customer. It means that
Mhm.
put up your photo ID and your real name and everything is associated with the account. They say that funds going from that account go through a series of addresses and two other Mt. Gox accounts, and then through a ARM exchange account, a Liberty Reserve account, and then pay for the DNS registration to the www.bitcoinfog.com Clarinet website. When now Clarinet, I mean just regular internet, right? So the mixer was an onion site on the Tor network, and you had to access it via Tor, but there was a link on the Clarinet site. Then they say there's where he made one of the first deposits in a Bitcoin Fog um, before Bitcoin Fog publicly announced its operation. But the problem with all these traces is that right at the first hop, like when you say hop, it's like, okay, I send from my wallet address or my Mt. Gox account, I send to another Bitcoin address, right? Just a string of numbers and letters. Usually, I think it's like between 30 and 40 or something like that, right? Now, right there on the first hop in all these traces, there's no evidence that Roman Sterlingoff had the private key to those addresses, which means there's no evidence, definitive evidence that he controlled those addresses, right? And it's entirely consistent with him selling Bitcoin to somebody in a peer-to-peer transaction. Even the government's witnesses, testified to that on the stand. There's no corroborating evidence. There's no eyewitnesses or anything. But what the jury bought into, and I think this is a bit of what's known as the CSI effect from the crime scene investigation shows you see in the United States and everything, is that the flow of those funds was the same as the flow of the control of those funds. And I mean, that's what killed us. And that's what, when we talked to the jury, afterwards, that's essentially what they said. They bought into these tracings, but there was no evidence that Roman controlled even the first addresses in these traces, right? And um, that's really, really scary, right? And because there were no eyewitnesses, nothing. When they arrest him in 2021, when he lands in LAX because he wants to go to flight school in Sacramento because he wants to become a pilot. When they arrest him, they catch him with his laptops, his hard drives, his password vault, his diary, his notes, and nothing in it shows him operating Bitcoin Fog. Now, what we think happened is that he probably ran into the people who actually started Bitcoin Fog in 2011
Mhm.
and maybe sold them Bitcoin, or did some kind of exchange or whatever. But what's really, really scary is he's facing decades in jail for money laundering, for something that we're convinced he just didn't do. And the other really scary thing about the case for me, and I think it should concern everybody because this could be anybody who's dealing in Bitcoin, is the venue issue. And what the venue issue is that, the United States Constitution requires that all criminal trials occur in the state and the district where the crime occurred. We're in Washington, D.C. on this trial, and Roman's in Sweden the entire time or traveling in Europe. There's no evidence of anything happening in DC except for these sort of sham transactions that these IRS agents do, right? That's not, I don't think that constitutionally gives the government venue because there's a huge problem there in that it, if that's right, it gives prosecutors almost universal jurisdiction because any prosecutor sitting anywhere in front of a laptop
Mm-hmm.
can do a sham transaction, say in whatever Montana, and next thing you know, you're on trial in Montana. You don't have any context there. You've never done anything. It's very, 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 very problematic. So this case is very. It's the first of its kind.
Mm-hmm.
Um, Nobody's challenged the blockchain forensics like this before. The judge, like judges do, it was no shock to me. Rubber stamped everything. At one point, actually, the judge about, and this, mind you, this is not early in the proceedings. This is about 2 years in the proceedings. The judge during our, what are called Daubert hearings, where we're challenging, the expert qualifications of the government witnesses and all that, the judge asked, does the blockchain have an administrator? Now, yes, exactly. If you know anything about the blockchain, that is displaying total ignorance of the blockchain because the core concept of the blockchain is that it's a decentralized ledger and doesn't have any administrator. It's a great question to ask if you're a beginner, but
Mm-hmm.
not 2 years into a case where you've jailed somebody pre-trial based on the weight and credibility of the evidence. And this is the same judge. He also wrote. So there was a company called Chainalysis,
Mm-hmm.
and they're the biggest blockchain compliance vendor out there. I think they've got something like $81 million a year worth of government contracts. They have almost a near monopoly in this space. And what they do is they do more than just basic blockchain tracing. Like if you do basic blockchain tracing, anybody can do it. You can go to like blockexplorer.com and look at the basic transactions on the blockchain. But the blockchain doesn't record personally identifying information about people. It doesn't record IP addresses. It doesn't record any of this stuff. So in order to make attributions about identity or that certain groups of addresses belong to whatever Silk Road or whatever, you have to use something called heuristics and sort of this probabilistic reasoning to come up with what are called clusters. And Chainalysis, even though I think they backed off when we came in and challenged it, the Chainalysis never, they actually came out and said, "Oh, we're not identifying Mr. Roman, Sterling off at all as the operator of Bitcoin Fog," even though I think, based on what I've seen, that they were actually heavily involved in that really early on because this case went on for a decade. But they came in and they said, well, here is all these clusters of darknet markets. All these addresses are related to Silk Road. All these addresses are related to whatever Agora. All these, addresses, and all those addresses sent money to Bitcoin Fog. So they're the software that was used to sort of attribute the amount of money, illicit funds used, mixed through Bitcoin Fog and the basis of that $334 million worth of money laundering charges against Roman. But what comes out, both in pre-trial and at trial, is that there's no scientific peer-reviewed papers attesting to the accuracy of Chainalysis reactor. They can't tell you its statistical error rate. They haven't done any internal error rate analysis of their software. It's a standardless industry right now because it's so new. And if you have any familiarity with sort of like the Innocence Project
Mm-hmm.
or wrongful convictions, 51% of wrongful convictions are based on junk forensic science. And what happens when, like this happened with bite marks, it happened with DNA, it happened with fingerprinting. When a new forensic science emerges, all these people rush in to make money off of it. And a lot of people get convicted. And I think that that's what happened here. I think the jury was impressed by sort of the pseudoscience and you know, also, the juries kind of default to the government. And so that's kind of it in a long-winded nutshell.
So let's start from the beginning, just to kind of build up the understanding of just how this whole mess came about step by step. What made the government think that Roman was the one operating this particular mixer? Uh, and why? And my understanding is that they were separately investigating the mixer for allowing illicit transactions with known criminal enterprises such uh, as Silkway and others, Silk and
Silk
others.
Road and
Yes.
Agora, yeah.
So who actually started that project, and how do they believe, and why did Rome, and at what point do they claim Roman came into the control of that entity?
That's a great question. I still don't know totally the answer to that. As far as I can tell, what happens around 2014, 2015 at Treasury, at the IRS, they are one of Chainalisis's first customers,
Mm-hmm,
and they start tracing stuff for Bitcoin fog. And one of the striking things about Roman is that he KYC'd almost all his accounts, right?
mm-hmm,
So again, that means know your customer. He's using IDs. So he has a Mt. Gox account, 2011, that he KYC'd, right? Even though it was optional
mm-hmm,
in 2011. I think the reason that they zeroed in on Roman is because he's the only person that KYC'd accounts back then that they could trace back to,
mm-hmm,
right? Like it was easy, right? And so, and I think he actually may have interacted with the people who started Bitcoin Fog, right? So, but he was like low hanging fruit because he's the only person who followed the rules, right? And the only person that they could identify, because he KYC'd his account. And then he used Bitcoin Fog. But when he used Bitcoin Fog, he took his funds post mix and then put them in his KYC accounts, right? And so this case, like they had him under surveillance in Miami in 2017 for like 3 months. No evidence that he was operating Bitcoin Fog when he was in Miami, right? Like they I think they just zeroed in on him because he had KYC accounts, and then they spent their entire time just finding ways to prove him guilty, never like thinking, oh, is this guy innocent or not, right? Like the because that's it. This case is really based on these traces from 2011, right? 13 years ago. And then them saying he took his funds post mix and put them in his crack and KYC accounts. There's no there's like nothing in any of the evidence of like him logging in as the administrator to Bitcoin Fog. There's no communications with him and anybody logging into Bitcoin Fog. What they said is that he controlled the accounts that ultimately paid for the DNS registration, which is not illegal, right? But this 2011 DNS registration, based on a IP address analysis saying that he used a server with the same IP address as the people who, whatever the account that paid for the DNS registration about the same time, like a few minutes apart or whatever, right?
mm-hmm,
Okay, well, if you consider the fact that we might be using the same IP address right now, or that thousands, tens of thousands, if not hundreds of thousands of people could be sharing the same IP address, on the same server, on a proxy server, on a VPN, whatever. Or if you're doing a peer-to-peer transaction with somebody, either in person or in a chat room in Europe or wherever, you might be sharing the same IP address. You can see the problem with that, right? But those were the biggest pieces of evidence that they had, right? And now he's been convicted of conspiracy to money laundering, failing to register with FinCEN, and then operating an unlicensed money transmission business in the District of Columbia.
So here's to convict somebody of a conspiracy, there must be evidence that there was a conspiracy, and that therefore that means more than one person. Who are the other suspects or defendants in that conspiracy aspect of the charges?
They basically listed the entire darknet. Like, I'm not kidding you. I'm not kidding you. Like, they were like the administrators of Silk Road, Agora, everybody. And there wasn't a single explicit communication. I don't even know it's implicit. Like, the whole theory of, conspiracy, they call the prosecutors friends. And, it's sort of a unique thing to the Anglo-American legal system. And it's notoriously plastic and pliable. Here they were just like, basically the conspiracy existed because people used Bitcoin fog. That's it. That's the basis for their saying that there's an agreement, and under this conspiracy there didn't need to be an overt act in furtherance of it, so it's not a common law conspiracy or 371. At this conspiracy, I can't remember what it was under. I think it was the money laundering statute. Conspiracy doesn't require an overt act. So there wasn't, like, it's not like they put on evidence of him talking to anybody about Bitcoin fog. That's what's so fucking scary about this case. It's all circumstantial evidence. Now, a jury can give circumstantial evidence the same weight as direct evidence, but there's not a single piece of direct evidence anywhere after a month of trial of him operating Bitcoin fog. And that's what's scary as fuck, right? Because this is just based on these traces that even the government's own witnesses said, listen, yeah, that's compatible with a peer-to-peer transaction. But, like, I asked a couple of witnesses, I'm so like, what do you have? And they're like, the totality. Okay, well, can you point to anything to me in the totality that's, him operating Bitcoin fog? No, it's just the totality of the circumstances. And that's fucking Orwellian, man. We had a faction of the jury that, bought into that. The jury was out for 2.5 days. And I think, based on our conversations with some jurors afterwards, I think a certain faction of the jury sort of hijacked the conversation. And,
So, well, this is what I don't understand. If there is a conspiracy, however big and broad and general, you would think that there would be other individuals who were likewise using Bitcoin fog at various points in time, who would be behaving at least as suspiciously, if not more than Roman, based on the fact that, it's a mixer and there were other individuals doing that. Was there anyone else interviewed, charged with similar charges? Were there any other
no,
people?
there's nobody. That's what's crazy, right? Like you're
I just find it incredible. If you have
it is, me too. I find it incredible too. But it's also like, that's also something, like, that's conspiracy for you. That's why they charge it. Like, that's why they call conspiracy the prosecutor's friend.
Well, but the whole point of conspiracy is to unravel other co-conspirators. If you only have one guy with nothing linking him to any of the criminal enterprises or criminal activity in question, I'm not entirely sure what they're getting out of it. Okay, they convicted him, but they got no further in identifying any other parties who were directly involved in the operations. They got no further information about any other criminal enterprises that were using this platform to launder, and they certainly didn't get anything in terms of any additional evidence for anything else they could use. That's the whole point of conspiracies, to take down a big ring. The Silk Road guy has been already convicted anyway, but as have been some of the other people. But you would want to identify any additional parties who were engaging in illicit activity using a platform, right? I mean, it seems very odd that they claim that this person acted in complete isolation, in this forum, that he simultaneously was engaged in all these transactions and yet had no contact with anybody and didn't know anybody and had zero, there's a contradiction to that assessment.
I agree. I mean, welcome to the case,
But
right? It's bizarre. I mean, like seriously, they listed essentially the entire darknet as his co-conspirators and didn't identify a single communication between him and any of the alleged co-conspirators. Not one. Okay. So this is not a case. Now you can have an agreement in a conspiracy that's implicit. So you have to go to the
sure.
implicit theory. And the implicit theory is simply that because these users of the darknet markets or whatever use the mixer, that's the agreement to conspire to money launder, right? Like it's and what's curious about that, I think one interesting thing to do with these Bitcoin cases and any of these crypto cases is take a step back and consider, like, flip it a little bit and just consider if it was just a normal bank. Under this theory, a bank is liable for money laundering when a drug dealer deposits cash into their bank account. There's no difference that I can see conceptually between that, but they don't charge the brick and mortar banks with money laundering unless the bank knows that the proceeds are illicit, right? And so there's a whole theory there that, well, you should have known that people were going to use it illegally. I mean, the um what's interesting, one of the interesting things to me about this case and crypto in general is they're applying standards that if you applied them to fiat currency, would not be accepted by the courts, like downstream liability for the flow of funds. Like, I mean, like, think about this flow of funds. Like, one of the things that seems to be that's coming out of this case is that people confuse the flow of funds with the flow of control, but
Mm-hmm.
of the funds. But the example I always give is if you go into Starbucks and you give Starbucks $10 to buy a latte, Starbucks takes that $10 and gives that to somebody else for change, who then goes and spends it at the local pharmacy. The local pharmacy gives that $10 bill as change to somebody else, who then takes it and buys drugs, illegal drugs, right? It would be like you, who gave that $10 bill to Starbucks, got arrested and charged and convicted for buying those illegal drugs. Like, they're imposing they're imposing upstream liability on the flow of funds without any corroborating evidence. Like, you can't do that. If you did that with fiat currency, like everyone says, there's cocaine on every piece of, US currency, right? We'd all be going to jail. You can't, like, the theory on a high meta level, the theory of liability is really whacked, right? And like, this is a really, really dangerous prosecution. I
Well,
think, if this is right.
let's flip it around and look at it another way. You know, can there be people who are using these mixers without, for entirely, does the government accept the idea that someone could be using these platforms without also being part of a criminal
Yes.
conspiracy?
Yeah. Yeah.
Well,
They're legal. They're legal. It's legal to
so
use a
so
mixer.
but it's that particular platform that came to be popular among various criminal enterprises, correct? For whatever reason.
Well, yeah. I mean, but like, it's not illegal to use a mixer, and that's not what he was charged with. He
Hmm.
was charged with money laundering. It's
But
illegal to money launder, but you can money launder through
so
your
they are
bank account.
claiming that not only was he the sole or the main controller of that platform somehow, but that he was also knowingly laundering money for these enterprises
Yes,
and not
exactly.
merely just participating in, like, without really looking at
Exactly.
who
Exactly.
was using it. So this
Yeah.
knowledge or intent element, what was the evidence for it basically does not exist.
Correct. And so that's why they asked and they got from the court, and this was, we fought, and this is another appellate issue, for what's known as a willful blindness instruction,
Mm-hmm.
which is essentially like, well, he should have known, right? Because there was no evidence that came in. First of all, there's no evidence that came in that he was actually operating it, right?
Right.
And then
We
there's
know that
no,
that would need to be predicated. The entire premise that he knowingly, money laundered and willfully ignored the flow of criminal funding. That's based on predication that he was in fact in control of the structure, right?
right, exactly. Yeah, exactly. Right. And then assuming that arguendo, he's operating it, right? Well, that's not illegal. But it is illegal to, they got the willful blindness instruction. It really is another thing that really vexes me about this case. And it's just saying, well, you kind of turned a blind eye to everything. But one of the problematic things about that is that it's essentially like it's applying a negligence standard
Sure.
in criminal law, which is a big no-no. There's so many issues for appeal in this case.
But
It's
let's for
astonishing.
a moment accept this premise that there is a willful blindness, that it's acceptable even if it's not.
Yeah, yeah.
Given that situation, there are, to my understanding, and based on government, own articulation of the use of, of the regarding these entities that are used as mixes, there's supposed to be a set of procedures you follow that indicates whether or not you were in fact willfully blind. So what were the procedures the government claims Roman ignored in this case that would indicate willful blindness?
They didn't, nothing, nothing. That was left to the jury. It was like nothing. I mean, this case is insane.
Well,
Right? It's
so
like,
wait, so how would they know that he was in fact ignoring the flow of criminal funding, or that he had any reason to believe that the criminals were using it, assuming that he was in control of this thing?
they brought in that Roman bought about like three, a little, like $360 worth of psychedelics from Silk Road in 2011 and 2012.
Hmm.
That's it. All right. Like he's not a drug user or anything like that, but like he did it, because for his depression. But so they used that to say, well, he knew that Silk Road was illegal. You could buy illegal drugs in Silk Road. And then they spent a ton of time talking about all the drugs that were sold on Silk Road and all the drug dealers, none of whom had any
And was
communication.
he using the mixer when he purchased those drugs?
No,
Oh,
no, he
okay.
wasn't. He did. No, he wasn't. Right. So it's like fucked, man. It's like, it's so, you could write a book on this case and it's the, just this case is really important because it's the first time this has ever happened just because of where we are historically,
Hmm.
right? With the and you know it's and the fact that there's no direct evidence at all, right? And I think what happened really is that they had this case sitting around for almost a decade. It's one of their first cases, and they wanted to wrap it up, and they rolled the dice thinking that when they'd arrested Roman, they would get all sorts of corroborating evidence and he would cooperate and take a plea, but they didn't.
Wait, so
And
wait a second. Something doesn't ring right, sit right with me. So they claimed he obtained illegal substances from Silk Road back in 2011.
uh,
When was he ever prosecuted for that?
no, he wasn't on trial for that. And here's another big point: is the statute of limitations on all these crimes is 5 years, and he's
Oh,
arrested in 2021,
so if
right?
they
So
had knowledge that he made that purchase back then, why didn't he just go after him right away for all the relevant violations and for purchase for illegal drug transactions?
because first of all, he did it in Sweden,
Oh,
not in the
okay.
United States, right?
Mm-hmm.
Like understand this is why venue is such a big issue here.
Mm-hmm.
He's not anywhere in DC. He doesn't know anybody in DC. There's no evidence of any transactions in DC except the government mixing in 2019. He's not on trial for buying drugs from Silk Road in 2011. right? I mean, the government brought this stuff in over our objection, Federal Rule of Evidence 403. It's, more prejudicial than probative. It shouldn't come in. I mean, we put in all these objections, right? But like, and he's not a drug user, right? Like this case is insane, right? And anybody who uses crypto should be concerned because if you send funds to somebody that later engages in criminal activity using those funds, they might come back to you and charge you with that crime because that's what's happening here. Right? Like you can't you're fucked. Right. And I mean, and this is just part, I think, of the United States government's like rabid attack on crypto, right? Or at least one faction of the United States government, because I don't think the government's this monolith, but there's a particular faction of the United States government that's obsessed with crypto and control, right? And
Well, this is what I also don't understand. Let's look at it from the other angle. Let's say you are investigating a conspiracy by which criminals are using some platform to launder their money elsewhere and make it hard to trace. Fine. So wouldn't you also be looking at where that money is actually going from the wallets of those known criminal enterprises and how they are getting to wherever they're getting cashed in, because eventually they get cashed in.
Well, that's where Bitcoin fog comes in because Bitcoin fog worked.
Mm-hmm.
So they couldn't trace where it went because you would take your funds, mix them, and then you put them somewhere. Like you can't trace through, right? So you can see stuff coming out of Bitcoin fog. You can see stuff coming into Bitcoin fog, but you can't, trace through Bitcoin fog.
But then wouldn't
So
it make sense to investigate uh, the both the recipients and the contributors of the fund? Yes, you can't figure out the exact path by which it reaches its final destination, but what have they discovered when they were going after the Silk Road and other enterprises, people using these mixers? And I'm sure they use more than one, not just this one.
I don't know. I'm not sure what you mean when you ask the question. What have they
Meaning,
discovered?
the criminals are not going to use just to just put all the eggs in one basket. They're probably going to use a variety of mixers. This
Yeah,
also means that they likely have a variety of people on the other end who are getting the currency out and cashing in.
yeah, yeah.
There is
I mean,
likely to be a pattern of who is receiving this ultimately illicit money, and it doesn't matter that it was. Let me put it this way: it doesn't matter how that money ended up in the hands of those other co-conspirators. The fact is, if they're active in both cases, if X amount of money goes in and X comes out, and the same, or people who are already known to be tied to those organizations are receiving them, and who sent it on the other end, then why wouldn't all these people be questioned about this? And wouldn't investigating them and their counterparts on the other end make more sense than investigating somebody who does not appear to be directly connected to any of these people on either side of the equation?
it's a great question. None of that happened
You
because that's
have
difficult.
X and you have Y and you have a question mark in the middle, but you still have X and you still have Y on the other hand.
That's just too difficult for them to do. I don't like. I don't think that they. You know. I mean, that's a great question. They just didn't do it,
Let me
right?
put it this way. This is kind of, the same way as with oil that's getting mixed to obscure its illicit origins. You have the oil, you have the Russians delivering oil to, say, Singapore, you mix it with some other oil, and then you go sell it off to somebody else.
Right.
You don't know exactly how many types of different oil, is in the oil that you end up selling off, but you do know that Russians did put it in location X and somebody else actually bought it. So if you
Yeah.
know that the oil is getting mixed, it doesn't matter how many stages of mixing it went through, you know that there's been, this activity that happened. So would you not be investigating A, the Russians, and B, the buyers who had good reason to know that the oil was not pure, oil from a legitimate source? You
Yeah, but
know.
that's a lot more complicated than
Hmm.
just singling in a one person who's KYC'd their account, right? Like imagine you have all these anonymous players and no information on them, and then you've got one person all the way at the beginning of the transaction who's written their name all over the oil, right? Like
Hmm.
that's what's going on here. It's not, and then you've got this long multi-year investigation with people coming in and coming out of it, and yeah, I no, I mean this. You're putting your finger on everything that's so problematic about this case, right? Like, it's not. Um, I mean, it's scary. I think this is a really scary case.
So
So
they
we
at some point decided that Roman is a flight risk, and that's why he's been in jail for this during the
3 years,
trial.
yeah, before trial, yeah, they decided it was a flight risk. The government kind of implied that because he had 4 passports when he was arrested.
So he had
Um,
the Russian and the Swedish passport, right?
yeah, he had 2 Russian passports because you need one passport to travel inside Russia,
Mm-hmm.
and then you need a second Russian passport to travel externally.
Also. Mm-hmm.
And then Sweden routinely issues you 2 passports.
Oh,
And the
okay.
government basically one because it's so that you can go to Jordan essentially and get your passport stamped, but then go into Israel without having a passport that's been stamped with Jordan, so you don't have problems traveling. Like Sweden does that.
Mm-hmm.
A few countries do that. But they basically implied to the court that these passports were forged, right? When look, they weren't. And number two, you could just check with the governments that issued them to
So
see if they
wait a
were
second. I
accurate.
don't understand this. If this is such a basic issue, why didn't they? Why wasn't, what was their response to the challenge on that ground?
Response to what?
To the
I wasn't
challenge? Yeah.
I wasn't on the case. We
Oh,
didn't
okay.
at that point, but look, judges, 80% of the federal judiciary consists of former prosecutors or
Mm-hmm.
people who've worked at DOJ. I mean, that's no secret. One of the reasons that the framers of the Constitution had and created an independent judiciary under Article 3 of the Constitution is because under the English system, the judges were part of the executive branch. They were part of, the crown, right? Like the crown's court, the king's court, all that stuff like that. What has essentially happened in the 20th century with the rise of the New Deal state and this massive expansion of federal power and federal criminal jurisdiction that's not in the original Constitution is you've kind of actually gone back to one of the things we fought a revolution over, and that the judges aren't independent from the executive branch anymore. They're very much, I think, part of the executive branch by virtue of the fact that they're in the same social circles. They've been working there. They're prosecutors. A lot of DOJ offices are in the same court building as the judiciary. So you've got this. I've had judges yell at me when I've questioned the integrity of DOJ and like say stuff like the freaking blah blah DOJ's integrity is unquestionable. Well, that would be a little shocking to the framers, because if you read the Bill of Rights, the philosophy underlying the Bill of Rights is not trust the government. It's the exact opposite, right? It's a series of rights protecting you against abuse of authority, but we've I think lost our way on that point.
So wait,
And
they claim that the passports were forged. First of all, if they were forged, are they claiming that he had a different identity?
they
If he's
implied
not.
they implied without saying explicitly
So
that
who
they
do they
were
claim this person actually is if he's not in fact a Roman
they didn't
Skeleton?
they didn't do any of that. Like this see like they get to play innuendo and they don't have to, the whole case is innuendo, right? And it worked, right?
I mean,
And
wouldn't they want to establish who he actually is? Maybe he has other crimes hanging over him if he's not who he claims to be. That's what I don't get.
they
If they
didn't
have a
well because they
possibility
couldn't
of building
they
a bigger
couldn't
case against a well-known international criminal, why wouldn't they do that? Why wouldn't they take?
because they didn't because they were his passports
Mm-hmm,
and he was exactly who he said he was,
mm-hmm.
and there's no record of him committing any kind of crime in his life. I mean, now he's got this, right? But because there was nothing there,
But
right?
why was he traveling with all the passports instead of just the Swedish passport or passports? I mean, he hasn't gone back to Russia. He wasn't planning to go to
Yeah,
Russia
he was.
after.
He did. He did. He had to go to Russia because this was
Oh,
during COVID.
okay.
So during COVID, this is 2021,
Mm-hmm.
the United States has a dispute with the Schengen zone, which Sweden is part of.
Mm-hmm.
And as part of this dispute, he had to go, he wanted to go to flight school because he was like, oh, I need to get a real career. I can't rely on Bitcoin, right?
Sure.
Because he gets into Bitcoin early and it's appreciates. That's what he's living off of, right?
Mm-hmm.
2014, he stops his job, but like, Bitcoin keeps going up and he's living off of it. So he decides to, oh, I want to become an airline pilot. So he signs up for a flight school in Sacramento, California,
Why not in Sweden?
because the best one was in Sacramento,
Oh,
California, because
okay.
he wants to be a commercial airline pilot. So he
Mm-hmm.
signs up for a 2 week intensive in Sacramento, California, but he has to quarantine somewhere. So the easiest place for him to quarantine because of this diplomatic dispute is in Moscow for 2 weeks before he flies to the United States. And he
Mm-hmm.
travels regularly, right? Like
Mm-hmm.
it's not a crime to carry four. This is what got me in this case. Is like I feel like there's this like provincialism with the prosecutors and everybody like, oh my God, he's got four passports. Well, like really, you're saying that in Washington, D.C.? Like there's when you could just probably look down the street and there's probably like a dozen people on the street with multiple passports, right? Oh my God, he was traveling with his computers. Yeah, he's a computer nerd. That's what he does, right? Like everybody, I mean, I've been, in this space for a decade. Everybody I know who's any good at computers is traveling with multiple laptops and all this stuff like that, right? But they tried to mystify it because to them, it's unusual. I mean, he was a bit of a digital nomad, and by
Mm-hmm.
that time, because the taxes in Sweden are so high, they're over 50%. He's spending less than his 50% of his time in Sweden, so he
Mm-hmm.
doesn't have to pay these really, really high taxes, right?
Mm-hmm.
And this is the other scary thing about this case. If you're not like everything to them was exotic that is normal in the space that he's in.
Mm-hmm.
And so you have this kind of like, the normies kind of prosecuting somebody that they think is weird and it must be criminal. Because I would never travel with three, a Raspberry Pi or a modem with like 3 or 4 SIM cards so I could stream. Right. And there's this sort of underlying provincialism to this whole thing. And then you mix that with the fact that Chainalysis hired one of the prosecutors from this case to be a senior legal advisor, that
What?
they hired their expert they hired from the DEA, that Chainalysis bought a company started by one of the IRS investigators during the pendency of this case. And the
Is that a
company,
conflict of interest?
oh, I think so totally. And we were shut down for being able to raise that as a defense. There's all sorts of money flowing from Chainalysis to prosecutors and government agents that I think fundamentally is corrupting justice. And I think that's a big story that needs to be investigated because I don't think that there should be any profit motive involved in justice. And I think that's what happened here. And the other problem I have is I don't think any of these forensic softwares should be allowed to be proprietary and black box. I think they should all be open source and they should all be scientifically vetted. And that is not Chainalysis at all. We were denied access to the source code. We were denied full access to the heuristics. We were asked even for the stuff that they were going to show us to sign a 5-year non-compete protective order, which has never happened in the history of the federal
Non-compete, but you're
courts.
not working,
Exactly,
this makes no sense.
exactly.
It's a
And
work, that's a work thing.
well, and I asked the court, I said,
Why
can
would
you?
you, they treated it as an intellectual property issue as opposed to a criminal evidentiary issue.
No, exactly. No.
That
And
makes no sense.
I asked the court, I said, can you name me a single instance in the history of the federal courts where a defendant has been asked to sign a non-compete in a protective order? And they couldn't. The only case they could find was a intermediate appellate court in New Jersey where something like that had been signed in a DNA forensics case. And like, I mean, that's why there's so many appellate issues in this case. Like,
So,
it's not.
okay, at different stages we've touched base throughout the trial, and there were a lot of questions, but at one point there were two things that jumped out at me. The government excluding at least one of your digital forensics experts, and the other point was a gag order imposed at one point. So what happened with those two issues, which to me seem very, very, very odd?
Well, they tried to exclude one of our experts, but what happened is we got CipherTrace, which is a MasterCard company, to come in, and we had an expert named Jonelle Still, and she wrote a really scathing report about Chainalysis and Chainalysis Reactor. And about a week or two before trial, after we'd agreed that no new experts could come in, CipherTrace mysteriously pulled her. And what they said was, oh, we discovered that there's all sorts of errors in the data that she was using for her analysis. We never got any clear explanation. She got her own lawyer, so we could never really talk to her. And then CipherTrace, MasterCard started shutting down, at least according to Forbes, CipherTrace.
What?
Yeah, no, exactly. It was weird. And it was, we got from the jury afterwards that they said, we would have liked to have seen somebody challenging the tracing a little bit more. Right. So we lost our top expert on the tracing because MasterCard, which controls CipherTrace, they just pulled their witness at the last minute without explanation. And I don't know if there were like backdoor conversations going on there, or, MasterCard was worried about its government contracts or what. I don't know what happened there, but it was bizarre. Right. So that hurt us. And then as to the gag order, so that there's a local rule in DC, local rule 57.7. And that says that no juror, no attorney can make any statement that they reasonably might think would affect, the jury pool. So, we started talking about this case, and the government went after us. And, my argument was we're not making any statements, on podcasts or anything that's going to affect a juror. And by the way, take a look at the case law in your district about the January 6th defendants, because they all raised the fact that there was massive negative publicity about themselves, when they asked for, a transfer out of the district. And all the district court judges basically said, well, the jury pool's so big that you don't need to worry about negative publicity. So I was like, are you kidding me? Right. But we just agreed to it because I didn't want the distraction. But now I can say, whatever the fuck I want. Right. But they were jumping on. And here's the thing is, the other thing I pointed out is like the government did press on this case. Like Roman, if you look at Andy Greenberg's Tracers in the Dark, right, it has a account of Roman's arrest and includes a conversation between the arresting officer and Roman. This was published before we went to trial. If you go in the index for that book, you can look it up, every investigator. You can look up the prosecutors, because they all gave interviews to Andy Greenberg. There's a through line here of careerism and profiteering that I think ultimately is a corruption of justice. And I don't buy for one fucking second that prosecutors are better noble beings than anybody else. They are ambitious and as greedy as the rest of us. And I think this case is a prime example of what happens when you have that kind of profit motive involved with a criminal prosecution.
Did they try to offer any plea deals at any point during the?
Yeah, they did. They did. First, it was 25 to life, and then it was 10 to life. But the problem we had is, they were like, you got to give us the private keys to Bitcoin Fog.
Okay.
Roman doesn't have the private keys to Bitcoin Fog. Roman didn't operate Bitcoin Fog. So you're kind of in a fucked position, right? They're like, we'll give you this plea deal, but you got to cooperate and turn over all the private keys. I don't have the private keys. I didn't do it. Okay. Right. Like what do you do? Like, if you're innocent and you're being offered a plea deal and you're being told you can get the plea deal if you turn over something you don't have. I mean, it's like a catch-22.
And did
Now
they
there's
ever they offer like any lesser included charges, such as,
no 10
no.
years was the best deal we got
Hmm.
offered.
That's very, very odd because, if someone did not actually operate that enterprise, why would he agree to any plea deal that wasn't anything more than just some symbolic probation sentence or something like that? It makes
We
no
asked for,
sense.
we asked for time served,
Hmm.
and they said no, you know. And mind
Yeah.
you, yeah, because I mean he's already done. He did 3 years of the trial. No, this case is crazy.
Okay.
Yeah,
So this is so the other issue that I don't really understand is that this is a criminal trial. This is not a preponderance of evidence civil
yeah.
standards. Why, clearly there's been, questions about many of these things. These questions in combination, whether you think is Roman is guilty or not guilty, the questions procedurally, in my opinion, are sufficient to raise, issues with the process of how all of this was being investigated. Even if you think that there's a very good chance that he was involved in something shadowy and was just good enough to evade detection, even still, that's not the same thing as having proved that he actually did those things. So why was the jury so clear, that this was, that they were able to accept all these things? Yes, even if you have some faction of the jury that's really buys into this, into this rhetoric, still there are others. Surely there would have been 2 or 3 people who would have had some serious issues with the way it was all presented. I
I
mean,
think
the
there
field
were.
is complicated enough even for experts. Forget the lay people who, you know.
I think there were. Right.
Mhm.
Like I think there were people on the jury, and I think there was a split between the white and the black people on the jury. Honestly, and I think that the certain white professionals hijacked the verdict. I mean, they were out for 2.5 days, which is it's a little long on a case like this. So I think there's really one of the points you're getting at. This is an issue for appeal is that there's insufficient evidence to find that he was guilty of this beyond a reasonable doubt.
Yes,
And
that's
I
exactly
think
what I was getting at.
what the jury bought into first, there's a certain trust of the government. For a
Mm-hmm.
lot of people, the government protects you. There's the CIA, CSI effect, not
Mm-hmm.
CIA, CSI. There's a lot of stuff. I mean, at the end of the day, I don't know, but I don't think when I look at this, and of course I'm biased, I'm his defense lawyer, right? But like I look at this, I don't see sufficient evidence to convict him beyond a reasonable doubt.
Mm-hmm.
I mean, there's just no eyewitnesses. There's no corroborating evidence. They brought in a couple other. They brought in Larry Harmon, who ran the Helix mixer, and they brought in Ilya Lichtenstein. And if you, both of them testified, oh yeah, when they caught me with the private keys. They caught me with all this stuff, right? And you don't have that in this context,
I mean,
And
presumably they assumed that if he had the private keys, they would be back, they'd be back in Sweden or in Russia somewhere, not
this
inside
is
the.
also another really striking thing. They did not search his Swedish apartment. They were
What?
cooperating. Yeah, no, that's what I was like, whoa. So he had a computer there, and they made this big deal out of because he knew how to use Linux, and they made this big deal. Oh, he's using Linux, and he got on the stand. He testified, no, I was using Linux to log into my home computer. Right?
Mm-hmm.
Nobody ever bothered to go search his apartment in Sweden and get his computer out of his apartment. That's really striking to me. Right? Because to me, what that says is, oh, you're convinced this guy's guilty and you don't even need to do the most basic thing. Right? Like, or you're afraid to go get that computer and find out that there's nothing on there. Right? Like, that's really, really striking to me. So I don't know. I mean, there's so much you could go into on this case, but I think that's it in a nutshell.
That's pretty unbelievable. And now, so you have, so what's his, has he been sentenced?
Sentencing is on July 15th.
Mm-hmm.
So we're getting ready for that. And then once the sentence is done, we file for appeal. And then that'll probably take 1 to 3 years.
And what do you expect the sentence to be?
I don't know yet. I'm like worried about that. It could be a long time. I don't like I have to go and do all that math and we're gearing up for that. And uh, you know, um, right now I'm like recovering from the trial. But I mean it can be, you know, normally sentences run concurrently, but if it runs consecutively, it could be over 50 years. Sam Bankman-Fried today just got 25 years.
Mm-hmm.
I mean, I'm guessing anywhere it could be like 10, I would guess, maybe. I don't know. Like it's really hard to, I haven't seen the government's calculations. The numbers are really high on this. Or at least they're going to come in with high numbers. So, it could be decades.
So I'm curious whether there's a possibility of a civil lawsuit against chain analysis.
That's why they didn't want to say that they identified him, and I
Mm-hmm.
think it's a lot harder with the guilty verdict. We're suing them for another client,
Mm-hmm.
civil lawsuit based on their attribution. And what came out during this is that a lot of people think that software is faulty. And another thing I think that's curious to me is that they kind of have a monopoly in the space,
Mm-hmm.
and they're completely unregulated and they're completely standardless. So I think there's, some issues there that need to go in front of Congress, that maybe need to go in front of the FTC, that need to be addressed, because I think these industries need to be regulated. And I think there needs to be standards. And I think there needs to be some scientific rigor brought into this space that doesn't exist right now because of just what's happening here.
I mean, so basically the entire digital forensic space, aside from this particular trial, hinges on identification issues that are basically run on the government side by one company.
Yeah, yeah, and there's some other ones like TRM but now CipherTrace is gone, but it's dominated by Chainalysis. Yeah, and Chainalysis has been very, very good, and you can see that in the history of this case in networking and hiring people from the government and buying companies
I
from
mean, it
people in the
sounds like some
government.
sort of a Gotham City criminal
It is. It is very much
enterprise
that. I know
in
it
itself.
is.
It's
Well,
a
it very much
little.
is. I mean, it's big business.
Mhm.
It's big business. Chainalysis is a company with an $8 billion market valuation, right? It's very problematic. But I also, one small ray of hope I get from this is now that this verdict has come in, people are paying attention, and we've been talking all over the place and talking to a lot of people who've got problems with Chainalysis. And so I mean it's very early in this. I
So
mean,
I'm
this is the
guessing that the reason the government, this case is important to the government, this particular type of defendant is important to the government because if the verdict stays, they can use it as a precedent for very broad prosecutions against these, individuals on very low level of evidence. And, this is a prosecutor's dream, not having to actually take down huge networks of enterprises. They just take down some guy claiming it's a huge conspiracy, and and that's
I
it.
agree.
That's your big career move right there, and
Yeah, 100%. 100%. Very
yeah,
much so.
I can see why that would be extremely problematic for many reasons. So I'm curious to continue following the appeal process and what happens with that. And I actually think that something like that is, these crypto issues and investigations, I think one day have a good chance of ending up in the Supreme Court because there's just so much
This
in
could
this
go.
area and just so little real understanding and quite frankly educating the jury on these issues must be very complicated, given that, you know,
I
most
think
people
there are
don't
issues
even understand what blockchain is.
I think there's issues in this case that can go to the Supreme Court, particularly the venue issue, because there's a circuit split on it, and I think it's such a major issue. I mean, the Supreme Court takes less than 1% of the
Mm-hmm.
cases that people ask it to take, but it, but over 80-90% of the cases that the court grants cert on involve circuit splits, and there's circuit splits on a number of issues in this case. This case is very, I mean, we knew going in. I mean, I learned early on as a criminal defense lawyer, you have to preserve the record for appeal. And there's a lot of stuff here. It's a very
Mm-hmm.
problematic case. And we're at the halfway point, and we'll keep you updated, check in with us. And
Yeah, please do, because there are broader issues here, and it is a novel technology area, especially in criminal justice. That's why I'm saying I think there is a a concern about how this technology could be used under what circumstances and what are the government's obligations when you have a near monopoly responsible for identification issues.
Yeah. Yeah. No, absolutely. 100%.
Well, thank you so much for joining us today. And for those watching the program, please stay tuned for our next episode next Tuesday night, 9 p.m. Thanks to Tor Ekeland for his valuable time and insights into an exceptionally interesting area of how blockchain, blockchain appears in criminal justice. And people like me have gotten a lot of this information from the government side during CLEs and so forth, but we are now getting to hear from the defense side on how these issues could end up being quite problematic for the defendants and people trying to defend themselves using very new technologies that have not yet been completely proven, to say the least. And thanks again, and have a great evening.
Thank you. You likewise.